Dishonor of check. Presumption as to legally enforceable debt liability. Section 139 is a reverse onus clause and requires the accused to prove the non-existence of the presumed fact, that is, that check was not issued in discharge of a debt liability. Accused is left with two options. First option of proving that the debt liability does not exist is to lead defense evidence and conclusively establish with certainty that the check was not issued in discharge of a debt liability. Second option is to prove the non-existence of debt liability by a preponderance of probabilities by referring to the particular circumstances of the case. Nature of evidence required to shift the evidential burden need not necessarily be direct evidence, that is, oral or documentary evidence or admissions made by the opposite party. It may comprise circumstantial evidence or presumption of law or fact. Once the accused adduces evidence to the satisfaction of the court, the burden shifts to the complainant and the presumption disappears. The onus having now shifted to the complainant, he will be obliged to prove the existence of a debt liability as a matter of fact, and his failure to prove would result in dismissal of his complaint case. Thereafter, the presumption under Section 139 does not again come to the complainant's rescue. Once both parties have adduced evidence, the court has to consider the same, and the burden of proof loses all its importance. Accused having miserably failed to discharge his evidential burden, that fact will have to be taken to be proved by force of the presumption, without requiring anything more from the complainant. There was fundamental flaw the way courts below proceeded on the premise that it was primarily on the complainant to prove the debt amount. Acquittal set aside.